Good evening, ladies and gentlemen. It is 7:18, and this is the Housing and Real Property Subcommittee. And this evening, we're going to be discussing two pieces of legislation. We're going to be discussing House Bill 477, and House Bill 477 is that landlord and tenant residential leases and holdover tenancies. The original title of the bill also included local just cause termination provisions. It is the intent of this subcommittee for HB 477 that we review the bill and its many amendments, and that we move this bill out of subcommittee this evening. That is the intent of this subcommittee for HB 477. We will also be discussing HB 693, that is Governor's Bill Renters' Rights and Stabilization Act, potential Stabilization Act. On HB 693, that will be discussion only. We will not be voting on HB 693. That bill we will be voting upon on Friday, this coming Friday. All of you probably have already received notification of today's meeting, Friday's meeting, and Monday's meeting with the subject matter which is included in those next two meetings. So the first thing I'd like to do, ladies and gentlemen, referencing HB 477, is to let everyone know that we had been working tirelessly on this piece of legislation, literally day and night. And what we're going to be discussing on HB 477, ladies and gentlemen, is how we have amended 477 to address everyone's concerns. Now, I want to make sure you understand what I mean when I say we have addressed everyone's concerns. Concerns were brought to us, and we have identified how we thought a best way to amend the bill to take care of the concerns. Now, that does not necessarily mean that what your concerns were, you will be 100% satisfied. What we have attempted to do with HB 477 is to dissect this baby perfectly and specifically right down the middle. And that's exactly what how we're gonna proceed with this. The way I'm going to move forward is, first, we're going to discuss, I'm going to outline the amendments to the bill. And then once I outline the amendments to the bill, then I'm going to ask Ben to be more specific in showing us where these amendments are in the legislation. All of you received very recently a new copy of the bill, which shows all of the amendments that we're going to be discussing. So you recently received a new copy of the bill as amended. So now what I'm going to do is briefly go through all of the amendments, and then after I do that, I am going to ask Ben to then pull up the bill and discuss them kind of one by one. But first off, let me tell you what the amendments are. We started out with discussions about breach of lease, and we wanted to make sure we were very specific in what constitutes a breach of lease in just cause. After that, we wanted to make sure we addressed the scenarios, to enforce substantial breach of leases. And then what we attempted to do after that is to identify what constitutes a breach of lease. And then and then after that, we set the floor for what is in fact called just cause. And by us establishing a floor on what defines as just cause, it makes it clear and specific in what we mean by it. And there was a question relevant to one place in the bill where it talks about permanently removing the house or the unit from from being rented, and we replaced that with a specific 1-year provision. The bill as submitted is called Just Cause, and we changed the name of the bill Just Cause and changed it to match a language that was in New York, one of New York jurisdictions. We changed it from just cause to good cause. You'll see that as well. And additionally, we were very specific in terms of how we addressed what is the grounds for just cause. And you will see those as we go through these amendments as well. There was some concerns and discussions about mom and pop exemptions from this good cause bill. And we have addressed that in this legislation with the amendments as well. And finally, there was some discussion about statewide applications. And those are also addressed in these amendments. And as I indicated at the top, ladies and gentlemen, it is the intent of this subcommittee to address and explain to all of you what the amendments are. And then it is the intent of the subcommittee to move the bill out as amended with discussion, obviously. So with that, Ben, if you do not mind, sir, if you could go through the amendments on the bill, Ben, please. And ladies and gentlemen, just so we get your discussion points, at any point along the way, if you have a question about what is being discussed, I want to make sure we address your question. So you do not have to wait till the end. You raise your hand and I will call upon you to address your specific concerns when they come up. Any questions so far? Great. Ben, if you could move forward with looking at and discussing the amendments, I certainly would appreciate it.
Okay, thank you, Mr. Chair, and yeah, thank you for and everybody who helped with this process. I really appreciate it. But yep, here we go. Here's the good cause bill. The first amendment the chair mentioned, you're going to see throughout the bill is replacement of just with good.
Good afternoon. Welcome to the House Environment and Transportation Committee for Wednesday, March 6, 2024. We have 140.
Okay, thank you. I'll keep going. Let's see. The next amendment we have is some of the amendments I'll note at the top here too. It may look like there's a lot of changes, but about half of the changes that are shown in the reprint before you will is partially just reorganization. So that's just one thing to keep in mind. So the first substantive part of the bill is amended. We have an exception for landlords that own 6 or more residential rental units. And we also have, similar to that, an issue was highlighted about, each landlord having a separate LLC, and then it having issues with trying to apply a mom and pop exception. So that's what we have with number 2 here. And then we have the bill applying only to the holdover tenancies as opposed to the renewal of a lease. Okay. Next in C here, we have the bill with counties may opt in. A county may enact by local law or ordinance provisions that prohibit a landlord from terminating a holdover tenancy without good cause. And again, that refers to the holdover tenancies. And if a county is opting in, they must adopt the following good cause that we've outlined. Now, some of the good cause grounds are the same or amended from the original bill. And the first one would be number one here is the substantial breach ground. That's an existing ground, although from the bill. However, there was one edit based off of making this a bill with counties being able to opt in, but having to opt in a specific way. Instead of having reasonable time period established by local ordinance, we went with 14 days. 14 days was the notice period for breach of a lease when there is imminent danger to the property. So that was the basis for that. And there was also, I think part of this approach was taken at least in consideration of the judiciary's testimony about concerns with conflicting standards being created by counties. Okay, the next one for number two here, this was a slight alteration of the original just cause ground from the bill. A tenant engaging in routine disorderly conduct that disturbs the peace and quiet of other tenants. That is slightly modified from what was in the bill, but only slightly adjusting the curing. Item number three here is another existing ground from the just cause bill, which is about the landlord or the tenant is engaging in illegal activity on the premises. Number four is another existing ground from the bill. It relates to the tenant refusing to grant the landlord access to the premises. So that's number four. Number five is a new ground, a tenant failing to accept a landlord's offer of a new lease agreement for a term that is at least 1 month, but not longer than the term of the lease agreement effective before the holdover tenancy. So whatever that most recent immediately effective lease was before the holdover tenancy was started, that's the term that's being referred to there in 5. Okay, so we have a 5B is a provision that was added within 5 as just another way, a period of time greater than 1 month after the landlord makes the offer, otherwise established by law, which is in consideration of circumstances when a law would require additional notice, such as a rent increase, to avoid a landlord trying to only have to follow the 1 month when in fact a longer notice period would be required. Item 6 here, we have a tenant repeatedly committing minor violations of the lease. This is something, we have the substantial grounds that was part of the existing cause in ground 1 of the just cause bill, but this was a new ground. But if a tenant is committing repeat violations that are minor and meet circumstances A through C here, then those would be another just cause ground for removal of the premises of a holdover tenant. Number 7, we have a tenant. This is another new ground. A tenant habitually failing to pay rent when due. If the tenant has been notified by the landlord in writing that the rent is more than 10 days late, at least 4 times in a 12-month period. Then we have another existing ground from the bill as drafted, which is a landlord seeking to recover the premises for their family. We have number 9, which is a new ground when the landlord needs to undertake substantial repairs or renovations and they've obtained necessary permitting. This would be another ground. A couple of these grounds have been in amendments in the past or for the prior bill. So that's just another thing to keep in mind too for why they were added. And then at ground number 10 here, a landlord in good faith seeking to remove the lease premises for at least 1 year from the rental market. That was a tweak to I had ground 6 of the existing bill, as opposed to permanently removing it from the rental market. We went with 1 year so that it was a bit more reasonable. And then we have at the bottom here with Roman numeral 3, a county may not adopt additional or alternative grounds for good cause. And that's in keeping with the approach of having a consistent and a uniform just cause framework throughout the state by the counties that are adopting it. Oh,
Ben, that is all of them at this point. Yep.
and sorry, and Chair Holmes, there are some more
I'm sorry, yeah,
amendments.
you have the breach of lease stuff to go through, yes.
Yeah.
Continue.
Okay, yeah, I think we're almost done, everyone. So
Yeah, yeah.
so yeah, that, and then on the last page here, we have in keeping with the original bill, as you can see, but there were a few more tweaks made. A landlord must enforce substantial breaches consistently. And that's just a safeguard against maybe a landlord playing favorites against one group of tenants or one tenant, that type of scenario. So that's what's intended to cover. And then here was just part of that was just a technical correction. So, and I think there are some questions, Chair Holmes, but
Sure.
I can keep the screen up if that's helpful, or whatever you think.
Yes, if you could keep that screen up, Ben, so that you can scroll to the specific line and page and line items when the questions are asked. I see two hands raised at this point, and I'm going to call them in order that I see them. Delegate Lehman, you have the floor.
Thank you, Mr. Chair, and thank you so much, Ben, for going over those slowly enough that I could, my tired brain could follow. I really appreciate that. My quick question is on page 4, where it talks about a tenant engaging repeatedly in minor violations. Is there a definition of repeatedly? X number of times in a 6 or 12-month period, or just because repeatedly is kind of vague?
It is, well, one of the things that we took some of this from was from some of the HUD definitions.
Okay.
Federal definitions. In not necessarily exactly mirroring, but that's where we took some of these things from. Ben, you want to expand upon that?
Yeah, thank you, Mr. Chair. And yeah, like you said, that's where that language is modeled after with HUD housing evictions. They have a similar statute for that resembles just cause, perhaps. And that's where that language was from.
Okay.
Yeah, that comes exactly comes from the federal wording. That's where we got that from. Federal definitions.
Okay. I mean, I think it was useful to have in that other section where it talks about late rent, like at least, more than 10 days, 4 times in a 12-month period. I know it's sometimes hard to quantify things, but repeatedly could mean a lot of things. Repeatedly could be 2 or 3 times, or it could be 10 times. But so I don't know that there's a right answer for it. I'm just concerned it's a little vague.
I appreciate that.
Thank you.
You're welcome. Delegate Healy, you have the floor.
Thank you very much. I want to apologize for being late because I had technical difficulty. I had the wrong link at first. And then I had to reset my laptop because I had to carry it from downstairs to upstairs and reconnect it. So I apologize for being late, but I want everyone to know that I did read the entire amended bill in between. So I am up to speed on that part of it. And I actually want to congratulate you, Mr. Chairman, for taking all the discussion we had last week and turning it into language that really mirrored all the concerns that we raised. And I'm very enthusiastic. I do want to be a co-sponsor of this bill now. Thank you.
Thank you so much, Delegate Healy. We'll have a pile-on in full committee. Delegate Noraki, you have the floor, sir.
Thank you, Mr. Chair. I also want to echo Delegate Healy's points there. Thank you for all the work that you and staff have done on this. Clearly, you've been very busy, sir, over the past week or so since we had our last subcommittee. I do have one question, and it could be just because I've missed it because there's so many amendments going on here. And I wanted to ask, so in some other just cause or good cause legislation around the country, there are definitions of basically protecting the health of other tenants as a good cause for eviction. Do we have that codified here in any of our amendments, Mr. Chair or Ben?
We don't have it in that particular language in terms of protecting the health and safety of other tenants. However, in our numbered items for good cause, I think it, by by purpose identifies that we are protecting the tenants from each other's bad behavior. If you go through those, like we've already done, you'll see that all of those items do in fact protect one good tenant from a bad tenant.
Well, Mr. Chair, where I was specifically going with that is, we talked last week about smoking, right? Smoking in a building. I'm thinking about tenants that may have asthma. That could be a health concern for a tenant that lives next door to someone that is smoking. And smoking in and of itself is not bad behavior. Obviously, it's a permissible thing to do, and may not be cause for an eviction. However, it could be problematic for other tenants nearby. So I'm just curious how that might be addressed inside of this legislation.
Well, you're correct. First off, it is not addressed in this legislation. And the reason why, one of the primary reasons why it is not, is because we are attempting to address items that are fall within the legalese or the legal items that we can, in fact, say someone is a breach of lease or holding over. We cannot legally at this point evict someone or put them out for smoking, because smoking is a legal activity. And if we're going to have legislation relevant to smoking, then we're going to have a different type of legislation in a different section or something. But we can't put someone out for particularly smoking. Now, there is legislation that we're going to be seeing that has smoking pushed to a specific area in a condominium, apartment, etc., but that is not addressed in this particular bill.
Okay, thank you, Mr. Chair. I appreciate that.
Yes, sir. Delegate Boyce, you have the floor.
Thank you, Mr. Chair. I wanted to respond really quickly to Delegate Naraki. I mean, that would essentially be a breach of lease, especially if in the lease, one is, for instance, not allowed to smoke, for instance, or not allowed to smoke on the premises, or so on and so forth. So I think the substantial breach of lease or a breach of lease would take care of that, especially if smoking is one of the particulars in the lease. So I think some of that stuff, health, welfare, could be linked to the lease in general. I wanted to go back to Delegate Layman's point about a tenant repeatedly committing minor violations of the lease. And so I think that is purposefully there to say 2 times or 20 times, because we talked about this, I think, when we were meeting about this. If you've got the person in the apartment building, with all due respect, that's the creep, right? You don't need you got 2 and 3 and 4 and 20 tenants telling you like this person is a problem, that's somebody you may not want to renew a lease for. And so I think it's broad so that it can address cases that are in some cases that are nuisance, but then in other cases are real substantial issues that don't need 5 times. It may just be 2 is enough. So I just wanted to put it out there that is broad enough to address some of those certain nuances that you don't want to get to 5 and 10 times, but 2 times may be enough. So, Mr. Chair, I just wanted to put that out there.
I do appreciate it, Delegate Boyce, and that's you're right. That is, and again, that comes from the federal definition as well. Delegate Baker, you have the floor, sir.
Yes, my questions will be fast and they'll just yes or no. This is an opt-in, so the counties would have to opt in to participate in this bill, correct?
Yes.
Okay. So
If you want me to expand, they have to opt in. If they opt in, they have to adhere to the rules that are on the paper in front of us.
okay, I understand. And I think the home builders or bankers were unfavorable. Have they changed to favorable?
I tell you, to tell you the truth, Delegate Baker, I haven't reached out to them to see if they have addressed all of their concerns. what we attempted to do, as I indicated at the top, we attempted to address everyone's concerns and, you know, split this baby right down the middle, as best we
How about
could.
the realtors?
Ben, if you could pull up, I don't have it in front of me. If you could pull up their discussion, I'll try to find mine as well. Ben?
It's on the screen, Chair, now.
Oh, okay. I apologize. I had to reduce my screen to just look at participants so I could see whose hands were up. So the tenant continues to cease and disorder, illegal activity. These are addressed in the amendments. Yes, sir.
Okay. How about judiciary?
Judiciary's concern was that we would have 24 different types of good cause. And by us making it mandatory, enabling / mandatory, there will not be 24 different types. It will all be one kind of good cause all across the state. By
Okay.
those who,
And then the last thing, you had mentioned LLCs. Would you go over that again?
yes, sir. The new language says, the new language says that if the owner has 6
Yep.
units, and if it's pull that up real quickly here, Ben. 6 units, and if it's an
Yeah.
LLC,
It's up, Mr. Chair. It's on B1I2, Delegate Baker.
there you go.
That it doesn't say LLC, but it says legal entity.
Yes, that's
Okay,
correct.
so you would have to have at least 6 or more, or seven or more units in an LLC to have to abide by this bill.
And we did that. We did that to protect the mom and pops.
Okay.
Because
It's 6 or more.
That was one of our discussions last week.
Okay, thank you.
Yes, sir. Delegate Lehman, you have the floor.
Thank you, Mr. Chair. So the question is about if you could clarify whether this is going to only apply to holdover situations. And if so, would that mean that a landlord could just refuse to renew a 1-year lease without having to adhere to these good cause standards?
Well, if the 1-year lease, let me back up. There are good cause reasons not to renew the lease, and the landlord has to adhere to all of those items. 1 through used to be 6. I think it's 1 through 9 now. And if the landlord is not going to renew the lease, then it has to be per the previous lease. If the last lease was 1 year, then they have to offer a new 1-year lease and then give the tenant an opportunity to not take that up.
Okay. But what the advocates are worried about is somebody that's on a month-to-month lease. And then when 1 year comes up and that expires, can a landlord just not renew it without good cause?
That's also in here. Ben, can you address that, please?
Yeah, thank you, Mr. Chair. And thank you for the question, Delegate
Thank you,
Lehman.
Ben.
Yeah, so the thinking here is these are the protections for holdover tenants. And you know, we laid those out. If a landlord's not renewing a lease and the tenant becomes a holdover tenant, then they would have those protections. So in a way, one way to think about it is it's adding you know, incentive for the renewal of a lease. Yeah, so that would be one. And then yes, it's correct. It applies just to holdover tenants.
So we would not be covering the good cause protections would not be extended to somebody on a month-to-month lease.
It just depends on their type of tenancy. If they are like a month-to-month tenant on a lease, then they wouldn't be considered a holdover tenant.
Okay, could you go back really quickly to what you said about it creating an incentive for what? For tenants to think maybe it's not so smart to be on a month-to-month and I'm better off. Or it would, yeah.
So these are the these are grounds for removal by a holdover tenant.
Or is there,
Um,
is there a place I should be looking right now? Because you've moved the
On the
screen a little
screen, on the
bit.
screen.
I know,
So-
but what line, whereabouts?
Oh, I'm sorry, I'm sorry.
Yeah,
I would say we'll start with C1I here. We have
Yeah.
a county may enact that prohibit a landlord from terminating a holdover tenancy without good cause. And then
mhm.
we have those grounds like 1 through on the next page. So yeah.
Okay. Um,
You good, Delegate Lehman?
yeah, I think, yeah, I still think it's a little bit
Look
confusing.
at number 5, Delegate Lehman.
In the tenant there, thank you, Vice Chair Boyce. The tenant there is the holdover tenant, just so that's clear. Yeah.
Tenant failing to accept a landlord's offer of a new lease agreement.
And I can provide a little background on 5 if it's helpful.
Say that again, Ben. Number 5 still only applies to a tenant in a holdover
Right.
situation. That's not meant to.
No, the bill applies strictly to holdover tenants, and if it's helpful, B1II here. I was mentioning about 5. The provision is about a holdover tenant accepting a lease from the holdover tenant. If a holdover tenant is just going to be perpetually a holdover tenant, 5 addresses that because it requires the holdover tenant to accept the landlord's offer of a new lease agreement for a term of at least 1 month. So in that way, it gets them back, removing them from the unpredictable nature of a holdover tenant and makes it just a tenant. Yeah.
Okay, one last question. Do we know how other jurisdictions deal with month to month? Is this typical that they're not meant to cover anything more than a holdover situation?
Well,
I'm just curious.
Typically, if there's let's take, for example, a 1-year lease, if the 1-year lease is not renewed at the termination or the end of the term, it automatically goes to a month-to-month lease.
Uh-huh,
It automatically goes to a month-to-month lease.
right,
That's an existing statute. And if the
okay,
landlord and or the tenant don't do anything to renew or enact a different lease, it stays as a month-to-month lease.
okay. But if you have a month-to-month situation, like right now, my daughter has a month-to-month lease, but it's only for a 6-month period on an apartment in New York. But at the end of that, whatever that, agreed upon term is that you go month to month, 6 months, a year, whatever that looks like, just to be clear, this doesn't offer the same level, the same kind of protection as somebody that was on a 1-year lease and then they're holding over, and have to be given the good cause for the landlord to say, you know what, I don't want to renew your lease for this or that reason.
Well, in the addenda and the amendments, it talks about a renewal of the lease in the previous term.
Okay. Okay. All right. I might talk to you a little further offline, Mr. Chair, just to make sure I can get my head around it, but it's getting late, so I appreciate the explanation.
Certainly. Delegate Baker, you have the floor. Uh-oh, you still there?
He took his hand down.
Oh, great. Delegate Naraki.
No hand up.
Thank you, sir. Appreciate it. Delegate Naraki, you have the floor.
Thank you, Mr. Chair. I did have 2 questions getting down to the number of units, the 6 units. My first question is, Yeah, because I represent a district that is in two jurisdictions. It's in Baltimore County and in Harford County. In that scenario, would we just be looking at the number of units in a particular county? Because I have folks that have, we're near the line there where you might have 3 in one county and 3 in another county. How does that work in that situation?
Well, the language in the bill does not specifically state if the landlord has properties in different jurisdictions. Ben, can you help us out here? That's a very good question, Delegate Naraki, particularly since in your case, Delegate Naraki, one jurisdiction may
Yes.
act to enable this and one may not.
Yes, sir. You're thinking down the pathway that I'm going in my brain there. Yes.
Yeah, I'm Delegate Ben. Delegate Ben, it's getting late.
Okay, thank you, Mr. Chair. I would, it's like you said, Mr. Chair. This is the broad application of the bill. It's to a landlord. It's not a landlord that owns 6 or more residential units in one county or in all counties. It's just, so it's in the absence of being specified, it's has the broad application to a landlord that owns 6 or more residential units. But it's a good question.
Mr. Chair, I think that could potentially be problematic there. I'm just saying that I could see folks challenge something like that in court. You could have one unit in Baltimore County and 5 in Harford County and be subject to this when the counties often take very different approaches to these types of policies.
Yeah, I appreciate that. I'll between now and next couple of days, I will get further clarification for you, Delegate Naraki.
Okay. And that, Mr. Chair, if I may, one more question.
Sure.
I'm just curious how we got to the 6 number. I certainly appreciate trying to protect mom and pop. So I'm just curious why 6, why not 10, why 6? Where I'm thinking with that is, it's really kind of two row houses, right? I mean, you could have 6 units very easily in 2 row houses. So I'm just trying to understand how we got to, and that's certainly still a very small operator in that case. So I'm just trying to understand that number, how we settled upon that.
And you are correct, Delegate Naraki. It is a small operator because what we're attempting to do here is to protect the mom and pop shops. And we're not trying to get the large property management companies the same type of relief. This is specifically for mom and pops. How we got to 6? We were attempting to find a number that was digestible to all people. 4 and over is sometimes looked at like a small apartment complex. We figured that 6 would be a number that most people could go along with. I reached out to another group that I'm a member of, the National Association of Residential Property Managers, and I talked to a couple of people there in that organization, and they agreed that 6 was probably a good number with them as well.
Okay. Thank you, Mr. Chair.
Yes, sir. Delegate Long, you have the floor.
Thank you, Mr. Chair. Very briefly, I want to make sure that we're clear. Again, this is opting in legislation. And are the commission and code home rule forms of government clear in how that process would work? Because generally commission forms of government have to come to General Assembly asking for permission anyways, more of a mama may I, right? So I'm just wondering, are they, if that is the case, will the commissioners need to come to the General Assembly and their normal letters of request via the terms of their local delegation asking for this to then be put a part of their local code?
The short answer is yes. And Ben, if you could expand upon that, because you're right, they do have to come and use your words, mother may I. And then once they are receive the authorization from the state, then they would have to enact this particular legislation exactly the way it's presented. Ben, your thoughts, please.
Okay, thank you, Mr. Chair. Yeah, that's something that we looked into. So in C1I here, we have a county may enact by local law or ordinance provisions that prohibit a landlord from terminating a holdover tenancy without good cause. So because it has this language here that they may enact by local law or ordinance. They don't need anything else from the General Assembly.
Oh, okay.
That's the enabling legislation. That's what makes it enabling. It enables all of them.
Yeah, but I think Delegate Long's question is that if we take Charles County, for example, they don't have the same type of authorization that Montgomery County has. Montgomery,
Correct. But
Montgomery,
this bill gives it to
Mon-
them. In this, for this one particular thing.
all right, okay, so.
I see what you're saying then. Okay, so basically, I'm sorry, Mr. Chair. So basically what they're
Yeah,
saying,
go ahead.
what they're saying is this was the permission if they needed it. But so they then are able to vote amongst and deliberate amongst their own respective bodies, just like a charter form of government would choose to vote amongst their council to adopt this code. If I just so I'm very clear, I want to make sure I'm clear because that can be kind of confusing, I think.
And I think what what Delegate Healy is saying is that the way this is written, if Charles County Commissioners decided that this is what they want to do, right there in that section right there gives them that authorization.
Yes, sir. Thank you.
All right, seeing no I'm sorry, Delegate Boyce, you have the floor.
Okay, so now I'm confused. So it gives them, it enables them to do so, but they would still have to locally adopt it.
Yes.
Yes,
Got it.
that's correct.
Yes.
Exactly correct. Yes. Yes. All right. I don't see any additional hands.
So move favorable on
is
the
there-
amendments.
Second.
All right. Thank you very much, ladies and gentlemen. There's a motion favorable and there is a second. And this is for the amendments to the bill. Any additional discussion relevant to the amendments? Seeing none, all in favor of the amendments to HB 477 signify by saying aye.
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 Thank you very much. Can I get a motion favorable
Move favorable.
Favorable.
on the bill as amended?
Second.
Is any additional discussion on HB 477 as amended? Any additional discussion?
Mr. Chair,
Yes, ma'am.
I'd like to say, this has been a 6-year battle. And I want to say, as someone who I think was a part of the initial battle in 2019, I'm glad to see that we worked to kind of get to the problem we're trying to solve. And I thank you for all your work in the background. I thank you for, reaching out to everyone, meeting with us, meeting with me, meeting with the chair, and keeping us in the loop so that we have something that I think gets to what we want to do, but also gets it in a way that we really do, I would say, protect the tenant, but also have some protection also for the landlord. So thank you so much.
Yes, indeed. And if I could extend, let's do this first before I go to my additional comments. We have a motion favorable with amendments. We have a second. I see no additional discussion. All in favor of HB 477 as amended signify by saying aye.
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 Any opposition?
No.
No.
That would be Noraki and who was the other one?
Baker.
Baker, Noraki and Baker. So the bill with them as amended passes. Now, what I want to do is I want to thank Ben. Ben has worked, as I indicated at the top, we have been working on this night and day. I've already offered Ben to take 2 pennies out of petty cash, but he decided to leave it in the bank for a future assignment. Thank you, ladies and gentlemen, for your patience on this bill. Now, ladies and gentlemen, as I indicated on our agenda, we're now going to go to HB 693. HB 693 is one of the governor's bills, and we've had there's been a lot of discussion in the background on this one as well. And what I'd like to do, ladies and gentlemen, I'll get you in a minute, Delegate Lehman. What I'd like to do, ladies and gentlemen, is I'm going to have Ben briefly discuss the bill, and then I'm going to turn it over to Brad Fallon from the governor's office to expand upon the discussion of HB 693. But before we do that, Delegate Lehman, you have the floor.
Thank you, Mr. Chair. I just wanted to be able to get a copy of the previous bill, of the amended bill we just voted on. I didn't see where that was sent to us. Can we get a copy from Ben or from where?
It was sent to the
That
email.
was sent
I'll
out. That
forward
was
it
sent
to
out.
you.
I'm sorry. Go ahead. Delegate Boyd.
Do we have it?
I'll forward it to you.
Thank you.
Yeah,
Thank you, Vice Chair.
It was forwarded to everyone prior to the meeting. But anyway,
I did not see it, but I'll look, but thank
okay.
you.
So at this point, getting ready to call you Delegate Ben again. At this point, Ben, if you could just briefly talk about the content of HB 693, and then I'm going to turn it over to Brad. I think he's still on here. Brad, or Chuck Cook is here.
I'm here, Mr. Chair.
Fantastic. So we have Chuck Cook and we have Brad, and they are going to they're going to piggyback on this. But Delegate Ben, you have the floor.
Thank you, Mr. Chair. I think I'll be an easy act for Brad to follow. But yeah, we're now looking at the Renters' Rights and Stabilization Act of 2024. This is a departmental bill. The bill increases the surcharge assessed for summary ejectment, tenants holding over, and specified breach of lease cases to $93 per case. I'll also note at the outset here too that this is a jointly assigned bill with Judiciary. In my understanding, Chair Holmes, just to be clear, was I think in our discussions was for voting on Monday, based off of, yeah, just to make that clear. But the $93 fee that Brad will get into hopefully is probably part of the main reason that provision of the bill we're going to get to look at is assigned with Judiciary. So that's just something to keep in mind with discussion and you know what we go over. The bill also establishes the Office of Tenant Rights in DHCD, and it provides a right of first refusal when for the sale of property with tenants. And it also expands the categories of eviction data that are collected by the Judiciary and provided to DHCD, and makes a few other changes. So I can pull up the, there's also a couple of amendments, Mr. Chair. I can pull up the bill if that's helpful for you and for Brad, and then I can also pull up the amendments as we come to the place that they would be.
That would be very, very helpful there, Ben.
Okay, I'll do that right now. 1 second.
And then that way, if Brad or Chuck start looking at the bill in their discussion and start looking at separate sections, you'll be able to pull that up as well.
Yeah, just and Brad, if there's anything, of course, if there's something to add, otherwise, you know, for the discussion part of the bill of the work session this evening, I can also flag some of the things we talked about with like the amendments that will be coming.
Well, thank you. Mr. Chair, how would you like me to proceed here? I'm happy to give an overview on the bill or follow the lead kind of chronologically as the pages come up.
Yeah, that's probably going to be helpful, Brad, so that everyone in the subcommittee has an idea of how the bill flows as you discuss it.
Absolutely. So
Ben, if you could pull it up, and then Brad, you could start the discussion simultaneously. That would be great.
And I believe it's up, Mr. Chair, if everyone can see.
Let me move my, like I said, I'm trying to keep everyone's faces here. Yes, you're right. Brad, you have the floor.
Well, thank you, Mr. Chair, and it's fantastic to see everybody. I know that we've had a lot of discussions about this bill. What I'll do is, Ben, if you will scroll along as I hit different sections, as I see them, I will just kind of make reference to where they are. So, of course, this is the governor's kind of omnibus Renters' Rights and Stabilization Act that we're very excited about. This first section looks to deal with the eviction filing fee. As a reminder for what we brought this, we have by far the highest eviction filing fee in the nation. It's 7 times higher than the national average. We're at 48%. The national average is 7. We also have the lowest in the nation eviction filing fee. And I may have just confused those terms. I apologize. We have the highest eviction filing rate, the lowest fee at $15. It says $8 here. There is another $7 applied, so we have a total effect of $15. The national average is $109. We have proposed, the governor has proposed, increasing this to $93 as a surcharge. So the total cost is $100 that is paid. That's below the national average, but addresses this issue that we have here in Maryland, where eviction filing has become a standard practice and a debt collection tool. There would be additional revenue, of course, obtained from this. Currently, about half of the fee, $8 of the $15, goes to the Maryland Legal Services Corporation. We propose that we keep that. 50% of the increase would then go to the Maryland Legal Services Corporation. We had proposed 50% also go to the statewide rental assistance voucher program, which the General Assembly created last year. And I know that there will be some amendments about where the money goes to this, and we're willing partners to work with y'all about that. The second component of this section, Ben, if you wouldn't mind scrolling down to the next page, is the pass-through, and is maybe the most essential part of this bill in the eyes of the governor and the coalition, which is that currently in Maryland, there is what's called a right of redemption. And that happens in 95% of all eviction filing cases. Sometimes it's higher, we're at 95% right now, where a tenant who has missed a payment, has an eviction filed against them, pays the rent back, plus the eviction filing fee, plus the court fees, plus a 5% late fee. What we're looking to do here is to say that the eviction filing fee of those costs, just those, are not something that is passed on to the tenant, but instead is a cost of business the landlord expends to file the eviction and move forward. So that's that section. Mr. Chair, would you like me to pause on each or just kind of keep chugging along?
I'll tell you what, that's a very good question, Brad. Ladies and gentlemen of the subcommittee, on this particular discussion, please raise your hand as you have questions so we don't necessarily have to go through the whole thing. So Brad, if you could pause for a minute. Delegate Allen has a question.
Thank you, Mr. Chair, and thank you, Brad, for being here. I do have a question. You're talking about the passing on of the fees there, and I remember there was discussion in the hearing about whether or not attorney fees and those kind of things are recoverable. Can you speak a little more to that? Find out, kind of clarify what is in this. Again, I'm not super steeped in real estate and these rules, so just kind of explain what we're talking about there.
That's an excellent question, Delegate. So yes, is the simple answer, and I'll provide some context to it. The court fees are recoverable. The Maryland system, as some of you who may be more familiar with the kind of landlord-tenant law, may know that kind of uniquely we have a landlord-tenant system where often landlords are able to represent themselves and not acquire an attorney. Although court fees are recoverable should this make it to adjudication when they come into court. That would remain this case under this bill. Same for the 5% late fee that may be applied to missed payments after that term. So this is really just about this individual fee.
Got it. Thank you.
Thank you, Delegate Allen. Brad, you can continue if you would, please.
And if I may,
Sure, go ahead.
Okay, yeah, thank you. If I may, and Brad, correct me if I'm wrong. I think this part was part of the amendments, which I can pull up if that's helpful, so that it's in
please.
Was that sound? Yeah, okay. One second.
Yeah, and what Ben's going to get to is the next section. We've had a number of conversations with public housing authorities. The reason I'm explaining why he's pulling it up is that we're actually proposing it be removed from the bill. As the statewide rental assistance voucher program gets stood up, we look to create some prioritization under it in line with the governor's kind of leave no one behind and child poverty agenda. There was some concern raised by various public housing authorities as they look to use this and pair it with the federal program. and look at the legality of pairing this with the Fair Housing Act under federal law. And we in no way want to make this more difficult for our friends at housing authorities. And so the decision that we made was to recommend to you all that this entire section be removed from the bill.
Great.
So happy to get in more detail, but that's our recommendation.
Delegate Long.
Thank you, Mr. Chair. Brad, I'm confused a little bit. Does any other state prohibit recovering of the filing fees?
No, so back on the other section, no. No other state has close to the system that we have. And I think landlords often will make that case, and I think they're absolutely right, because everybody here is in good faith, and I truly believe that Maryland has an interesting dynamic in our entire eviction filing, our eviction law, really our landlord-tenant law. We agree completely with them on that. In that vein, though, we do have a massive problem here in Maryland with eviction filings and the impact that that has on people. And so what we're proposing is a Maryland unique solution to a very Maryland unique problem. And so take the fee here. Say it's it's $15 currently. Right now, the median rent in Maryland is $1,800. 5% of that is $90. So currently, right now it's recoverable, but say it wasn't. You would take $90 minus 15, you still end up more than whole, right? Say it was $100, you end up paying $10, right? So there is an interesting kind of financial impact there, but it is a unique policy that we're proposing.
Thank you, Brad.
Delegate Boyce.
So I was following and now I'm confused. So let's go back to what was struck from the bill. I see the 50, all of the public housing provision was struck. Is that what you're saying?
Yes, so just the changes in the bill. This is Delegate Boyce, the program that the General Assembly created last year, the statewide.
Yes,
we're not changing the program. We were looking to create some prioritization for families with children under the age of 5 and for pregnant people. With the concerns that I mentioned with public housing authorities, we've just said, okay, we don't want to make this harder. We will strike that and maybe consider bringing it at a later session.
Okay, so then my second question was going back to Delegate Long. So I thought you were saying the landlord can no longer, so if this fee is going to be $100, they can't pass that $100 on to the tenant?
That's right.
Okay, just clarifying all of it. So no part of it can be passed on.
That's right. And the fee itself, it does not fund the court cost. It's somewhat of to put it in tax terms, kind of an excise fee.
No, I just want to know, so we're not any of it is passed on. No, okay,
Yes,
thank you.
Right. Go ahead and continue, Brad, if you would, please.
Absolutely. So let's see what the next section is. So the next section creates the Office of Tenants' Rights. Right now in the state, the only real public resource that we have is under the Consumer Protection Division of the Office of Attorney General. Some local jurisdictions have tenants' rights offices or something similar. And what they do is they intake concerns from tenants that may be having an issue with a landlord or whomever, and they are able to provide them the rights under law and act as an ombudsman to connect them. That's a resource that we're hoping to make available here in the state, statewide. The second component of it is that they would create what we're calling the Maryland Tenants Bill of Rights. That does not allow them to create new tenants' rights. It allows them to take the tenants' rights under law, put them in a single document, require that be an addendum on the lease, and so that when it's signed, both the tenant and the landlord have made a note, have indicated that they understand the rights under law and that they have a resource in the Office of Tenants' Rights. I'm happy to get in more detail in that section. There's a lot I could go down. There is a May section there in 5104B that I would just shout out. And it allows the office to implement fair housing testing and to identify landlords that are out of compliance. That may not be something that everybody on the committee is familiar with. What fair housing testing looks like is that, for instance, say that there were a third-party contractor hired, say that there were 2 people of color and 1 Caucasian, they would all come and inquire about the availability of a unit. If, say, the Caucasian individual was said, yet this is available, and the other two were not, that may be evidence that fair housing laws are being violated. That's an authorization.
Hang on a second, Brad. A question from Delegate Naraki.
Thank you, Mr. Chair. Brad, I'm just confused. I just wanted to kind of go back to the filing fees for a second, just to circle back there. So are they still unrecoverable in the way that this is drafted, or have there been amendments to address that with the filing fee being unrecoverable by the landlord?
They are unrecoverable.
Okay, and what is the reason for that? Because in my understanding, there are several other states that that they are recoverable, including states around us.
Yeah, that's right. And that goes to Delegate Long's question there. Really because Maryland has what's called the right of redemption. And the many states have that, many de facto have that through the process. What happens is that this fee is filed and it's immediately passed on to the tenant, who then pays the fees for this filing, right? If you increase the fee and you do not block the pass-through, what you end up doing is making it harder for somebody to pay back the rent and remain in the property to redeem under this process that Johnson was creating.
But Brad, if the fee is unrecoverable, don't we anticipate that ultimately landlords would pass that on to tenants in the form of higher rents? And doesn't that kind of go against what we're looking to solve here with affordable housing?
No, sir. So we do, as I mentioned, our eviction filing rate is down in about half. It was about 95%. Now it's down to 48% because of very wise decisions by the General Assembly to require a 10-day notice. That is still by far the highest in the country. And so I think what I would present is that either Marylanders are completely unique when it comes to 49 other states in the District of Columbia and that they don't pay their rent, or we have some potentially trigger-happy processes here that were created in good faith. And now landlords are making rational business decisions to file a fee that they can then pass on to the tenant, instead of reaching out and having conversations to ensure that the rent is paid. And so what we would anticipate is that when this is filed and when it's not passed through, we will see a reduction in the actual filing rate, as we've seen in every other state in the country.
So I guess maybe to Delegate Long's question, then why would we not allow a judge to make that determination whether a fee should be recoverable or not?
Same process, right? In that what we're proposing is that is kind of what the simple process looks like. The vast majority of these are not being ordered by a judge, right? 40% of these cases there is a redemption, essentially a de facto redemption, where they paid back the rent due plus the 5% late fee plus the eviction filing fee plus any court fees that were already incurred before they ever even make it to court, right? And so in those 40% of cases, that individual would end up paying that back regardless. Right. But ultimately, this is an incentive and a behavioral structure. Right now, I think that the governor thinks that policy has created where landlords use this as somewhat of a debt collection tool. That has resulted in a lot of costs for the judiciary, for sheriffs around the state, like the Baltimore City Sheriff testified at the hearing. And our belief is that if they can't recover it, they may still make that decision because it's a whole lot cheaper than not getting rent paid plus a 5% late fee. But they may take more consideration into reaching out and having conversations with the tenants.
Okay. Thank you, Brad.
Thank you.
Delegate Bush, you have the floor.
I'm going to take a second crack at this and somewhat play devil's advocate. So yes, it's the cost of doing business. I decide to file for a person who more than likely is going to redeem. So yes, I could see that. That's the cost of paying, that's the cost of business. You pay your $100, it's $1,500 in rent. You can eat that cost. I get that. What about the opposite? Could a landlord then, for someone who doesn't redeem, could a landlord essentially, when they do seek or sue, request kind of a redemption of the costs that they had to file to get a person out who essentially did not redeem? It's just a question.
So you're saying if there's actually an eviction,
It's an actual eviction, would it be given again, the $100 is the cost to do business. I get my rent. Okay, that's the cost I eat. Maybe I should have waited a day or more. I could have gotten my rent. But in the case where they don't pay, is it appropriate to say that the landlord could then seek those filing fees when they get the rent or don't get the rent, or in some cases, if they sue for the rent, could they then also include those costs?
So that's not permissible under the language here. I'm very, very happy to follow up and have this discussion in more depth offline where when I can get some more information about what suing looks like after somebody's been removed. I'm not sure that the administration would look to for someone who is just evicted from their home to have to pay more.
I get that, but it is a question because you stated that it is the cost of doing business, which I think I agree. If the cost for doing business every month for me is to pay $100 after I wait 10 days for money that I know I'm going to get, then you get to eat that cost. Personally, for me, I feel like you get to eat that cost. I don't think you should get your money back with all due respect. But I guess what I'm saying is what happens in the opposite, and it's not. It's just a question. I'm not asking for a change of the bill, but it is a question.
Okay. Yeah, under this bill, it would not be permissible for them to sue after the eviction has gone through and someone is removed to recover the eviction filing fee.
Delegate Allen.
Thank you, Mr. Chair, and I'll be brief. Yeah, I was basically going to ask pretty much the same thing that the Vice Chair was asking Brad. If you could just give us more detail about that whenever you get a chance. Because I am curious what role, if any, a judge would play in this scenario, and again, like you said, if the administration would feel comfortable amending it to allow judges to play more of a role. You know what I mean?
You got that question, Brad?
I do. I'm sorry. I thought the request was to follow up online. I'm sorry if I misunderstood that.
Yeah. But did you understand what the question was, Brad? Because it kind of got garbled on my side.
So my understanding of the Vice Chair and the delegate's question is once somebody they have been removed from the property for failure to pay rent, they have been actually removed, right? There's a sheriff's office has removed. If somebody could then sue them to make up for the rent and then recover the filing fee at that point as well. And I will get more information about that process, the usage rate, by how often landlords are actually suing once somebody's been evicted to recover missed payments, and I will circle back to that information.
All right, and I apologize because, like I said, Delegate Allen got kind of garbled on my side. I don't know if it's the wonderful Wi-Fi system we have here in the building or not, but Delegate Naraki, you have the floor, sir.
Thank you, Mr. Chair. Brad, I got a lot of thoughts in my head. This one just came to me. So what about, and this is in light of the good cause legislation we just passed. So what if you have a tenant that is habitually late? Is the landlord expected to, continue to pay that fee if you've got a tenant that's late 4, 5, 6 times in the term of lease? I mean, is there some number? We said 4 in good cause. Is there some number here that would trigger where there is something going on with the tenant, not the landlord there?
So tenants have 3 rights of redemption in state law. They have 4 in Baltimore City. And so there's only so many times that this could be applied. So say in line with the just cause legislation, should there be a redemption utilized under the law here, they could only do that 4 times or 3 times, depending on where they live.
But so the landlord then, say they're in Baltimore City, in the case that the example you gave, they would have to pay, they would not have those fees recoverable 4 times?
Yes, if somebody did that, yes, they could do it 4 times. Now, yeah, I think that's just the answer to the question.
Yes, that's the answer.
Thank you.
Thank you, Delegate Naraki. Continue, Brad.
Yeah.
All right. So I was working through office tenants' rights here. Happy to pause for a second if there are any questions, and otherwise I'll keep moving along.
And Brad, just so the subcommittee is aware, there was one of the amendments that was discussed was having the Office of Tenant Rights refer individuals as defined, in the real property article, to the access to counsel and evictions program that is administered by the Maryland Legal Services Corporation. And then there is a separate amendment about having the Office of Tenant Rights collaborate with county and local government entities that provide tenant assistance where applicable. And then just a couple of like regulations and receiving notices and documents related to the negotiation period and right of first refusal, which I think leads into the next part of the substantive amendments from that you had helped me out with.
Absolutely. And thank you for flagging that, Ben. So, and I'll map back to that at the end of this. So we are proposing what's called the right of first refusal in this legislation statewide with amendments, which is what I will present on. It's probably more accurate to call this a right of first offer and a right of first refusal. This is modeled after a Baltimore City model. You may have seen that realtors and the Maryland Land Title Association had significant concerns about this. We worked with them ahead of the hearing, so they were able to come in favorable with amendments with these amendments here. And what they look to do is that they tighten the definition of tenant to simplify the process to make sure that there's somebody on the lease who is counted there. It incorporates exemptions that we see in other jurisdictions. Those are things like, say it's you're passing on a home to an individual, it's a public housing authority selling, all sorts of things, and I'm happy to run through those. It does require that the Office of Tenants' Rights receive a notice to a tenant so that there is some verification that that this notice was definitely sent out. That was a request from the Land Title Association and the realtors, and it requires that the notice sent is required by track shipping. It also lowers this from applying to properties with 4 units or less to 3 units and less. And then the actual process looks like between 60 and 120 days of a property being put up on the market and listed for sale. The owner should reach out to the tenant as long as they live there for at least 6 months and offer them the price. And they would have a 30-day period of exclusive negotiation where the tenant could say, hey, I match your price and I can purchase this, maybe using something like the Maryland Mortgage Program that the state offers, or they just have the cash on hand. They could also say, nope, I am not in a position right now where I can purchase. And at that point, they have waived their right of first offer and right of first refusal for the property. On the back end of that, if a landlord has a tenant and they just receive an offer out of the blue and it's something that's too good they can't take, they can offer that to the tenant and the tenant will have a right of first refusal. They would again have a period of 30 days to make that determination. During the period, by the way, of exclusive negotiation during the right of first offer, we did streamline this to match the offer and counteroffer process. There's a 5-day period in both directions there. The other time that the right of first refusal may come into play is if there was a first offer. So say that there was a property and they say, tenant, if you could purchase this at $400,000, it is all yours. The tenant says, nope, I can't afford it. But then on the back end, the seller gets an offer and moves towards a sale at $200,000. Since that is more than 10% less than the price that was offered to the tenant gets another crack and they say, hey, tenant, I know you waived this, but now you have 30 days to make a determination. If you can afford this at $200,000, you have the first right to refuse this. That more or less is the entirety of the section. There are a few other things that point out just that you cannot sell your right of first refusal, as you see in some other jurisdictions, that you have to be there for at least 6 months, and that the Office of Tenants' Rights plays a function here, as Ben mentioned in the previous section.
I don't see any additional questions. You can keep going there, Brad.
And Brad, this is the next part, 8.120 is about the gathering and monitoring data. That was, I think, part of the added language.
Absolutely. So, yeah, there is I'm sorry, I'm going to make sure that, yeah, so this is related to the right of first refusal as well. What some interested stakeholders pointed out was that there may be a disagreement about whether the notice ever went out if a tenant does not respond. This allows, since the Office of Tenants' Rights will be collecting that data about the notices going out, that if for any reason they need to prove in a court of law that this notice did go out and they can move forward with the sale, that they can collect that data.
Great. And then the next part, let's see. I think that was the emergency. Yeah.
And that's right.
So then, yeah, Brad, then at the end of the bill, they have, there's some tweaks to the execution of the warrant of restitution in the event of extreme weather conditions.
Absolutely. And Ben, on the left-hand side, I think we did move back to security deposits. I'll do the other one, and then I just did want to reference that as well, the 1 month.
Okay.
So on the first part that that Ben brought up here about eviction stays. So currently under law, in extreme weather conditions, an administrative judge can delay an eviction, the actual removal from the property. After everything has been adjudicated, the individual comes up. That has become fairly standard, and that administrative judges will offer this. We have not defined what extreme weather looks like, and it's a may, not a shall. So there is a process of review before that is issued that frankly is burdensome on the judiciary. What this looks to do is define what extreme weather condition is. After some deliberation and a lot of consultation, the list on the right-hand side is what we have come up with, which is temperature below freezing, a winter storm warning or blizzard warning from the National Weather Service, a hurricane warning or a tropical storm warning from the same place, an excessive heat weather warning, and that would be it. We did remove an emergency declaration from the bill because it was pointed out that sometimes those can last for quite a long period. I would point to the opioid crisis and the emergency declaration that was declared there that lasted for years as an example. This is really just saying that if you're being removed from your home, which is a natural recourse and legal remedy in many cases, that you should not be out on the street when it is absolutely below freezing or there's a blizzard outside in those sort of cases. Thank you for that. Ben, the other section that was on the left-hand side that we blew past there just a little bit.
Sorry.
No worries at all. Is the security deposit section. So currently under Maryland law, security deposits can be equivalent to 2 months rent. For context, that means that if you're moving into a property, you need 2 months rent plus the actual first month's rent to get through the door. 12 other states and the District of Columbia have moved towards reducing that to 1 month's rent so that you would need to pay the equivalent of 2 months rent to actually get through the door and start renting. And we are proposing that we do the same. There are two components of that. That makes it a lesser burden for those who are becoming housed to get through the door and become housed. And second, sometimes people just need to move. Whether the tenant, the landlord sold the home or there's an issue or what have you. In that case, they may need to come up with, say, $5,000, $6,000 to get to a new home that often can completely clear out their savings account and create economic instability.
And Brad, where in the bill was that what you were referring to?
I'm sorry, now I'm
yeah.
a little bit. It is up. You can see where it says 1 month. I think it's up in the next section, the next page. I have lost it.
That's okay.
Well, I'll tell you what, let's do this. Delegate Naraki has a question, and then we'll come back to that 1 month versus 2 month scenario. Ben and Brad. Delegate Naraki, you have the floor.
Thank you, Mr. Chair. Brad, just a point of clarification on the emergency declarations. I'm thinking about, say, a hurricane. Maybe it affects the Eastern Shore or the middle part of the state, but say Garrett County is not affected in that. What happens in that situation? Does that apply to Garrett County as well, or does it apply only to the areas of the state that are affected in that emergency declaration situation?
That's a fantastic question. So the emergency declaration is the part that we're looking to remove from the bill. And so it's not region specific on that. Certainly the intent, and as listeners contemplated, is for the weather that it impacts the region that the tenant actually lives in. I will clarify that because it's the first time I've been asked that, just to verify that we don't need a finer point on that. So let me circle back with you on that, Delegate.
Okay, thanks, Brad.
Of course.
Ben, have you found the 1 month versus 2 month section yet?
And Brad, is that 8203 here? A landlord with a security deposit in excess of 1 month's rent per dwelling unit?
Yes, sir. Yep, that's it.
All right. Any questions on that 1 month versus 2 month scenario before I move on to Delegate Lehman?
Yeah,
seeing
thank
nothing,
you. I was
Delegate
just gonna
Lehman,
say-
you have the floor.
Yeah, I was gonna say quickly, I think we went over that. I saw it in right on line 25 and 26. So, okay. And how many states have the 1 month requirement for security deposit, Brad?
That's 12 and DC. So depending on how we consider 13, 12 or 13. And I'm happy to provide which states those are as well. It
Okay,
really
just-
doesn't break. Yeah, please.
Please do, Brad.
Happy to.
Okay, thank you. Yeah, I was just curious. Thanks.
And we've gone through the entire bill. Haven't we, Ben?
And thank you, Mr. Chair. There's one other part that I was able to talk with Brad about too. This has been the product of working with appropriations and Ways and Means and yourself. There was Brad, when he was helpfully going over the surcharges and their assessments with the 50% breakdown. There is a bill right now where if subject to the passage of HB 428, there is an amendment for it to be 10% into the rental assistance for community schools families fund. So that and for people who may be unfamiliar, that is a program that is it provides rental and utility assistance to eligible households directly to a landlord or utility companies to assist with rental payments, utility payment arrears, fines associated with those payments. And the households can receive the support for up to 12 months, but subject to the availability of funding, can be extended for up to additional 3 months. And eligible families are assistance is for students in the family. They must be enrolled in a school that receives funding under the Concentration of Poverty School Grant Program. They have compensatory education enrollment, rental property where at least one household member is at risk of homelessness. Then there's some more information in the fiscal note for HB 428 on that.
Thank you. Delegate Lehman, you have the floor.
Yeah, just I'd like to get a copy of this. I checked my email and I don't think we've seen this. Can we get the PDF of these amendments as well?
I second that.
Yeah, I'm working on putting that together, but definitely, definitely in anticipation of the Chair Holmes' schedule next week with voting. There'll definitely be something, similar perhaps to the process that we did for Good Cause.
Great, thank you.
Delegate Naraki.
Thank you, Mr. Chair. Sorry, I was having trouble with my computer there. Brad, I do have a question about the 1 month versus 2 months. Do you think that landlords would be less willing to rent to tenants with a breach of lease in their past if they capped it, if we capped it at 1 month versus 2?
I've certainly heard that argument, and it was presented well by the larger landlord representatives at the hearing. Here's what we did. We looked deep into that because we take that really seriously about whether it would hurt somebody's chances of becoming housed. In the jurisdictions, in the 12 states in the District of Columbia, where they have adopted this policy, we could not find anywhere, and talking with national experts and doing our research, anywhere that has shown that it has increased the rates of homelessness or decreased the rates of tenants, right? Or reduced even the number of rental houses on the market. And so I think it's a rational and good faith argument that's being made and that informs the question there. But we just can't find any evidence that that's taken place.
Okay. Thank you, Brad.
Thank you. Delegate Boyce.
And thank you so much, because I do know security deposits are a huge barrier to being immediately housed. I do want to, Brad, ask about, so then how is it assumed that no matter the property, 1 month's rent worth or deposit worth of rent satisfies any issues with the property when the tenant and the landlord part, or when someone moves. Like, does that cover the cost of damages, so on and so forth?
It may not always, and that is the case for the 2 months rent as well, right? Which
Yeah.
is why there's a process to recover that should it be in excess of the security deposit. That would be maintained.
Yeah, that makes it hard because I would hate, I mean, I would rather, well, I got a bill for that, but I don't think it's gonna happen. I don't know. But I was gonna say I would hate, well, one, the ease of getting into the property turns around if there is damage, then I'm being sued because I didn't put enough up front to cover quote unquote costs, because the landlord can as I know it, and somebody can correct me if I'm wrong, because I may be wrong, that any money, any damages in excess of the security deposit, they can sue for. Isn't that correct?
That is correct.
So I'd be worried with either normal wear or tear, or God forbid, whatever happens, that then the tenant would then be sued for the additional costs needed to turn over the place of residence.
Well, to that point, Delegate Boyce, normal wear and tear is not charged against the security deposit.
Okay, so
and
so it's just damage.
Go ahead.
No, Chair Holmes, you're saying it's just damage, like excessive damage covers.
That is correct. Normal wear and tear is not at the expense of the tenant.
Okay, and we're sure that the tenant won't get dinged for the 1 month, like dinged on somewhere, like they just end up getting somehow. I think I'm good. I think I'm overthinking it. I just don't want the tenant dinged somehow. I got you.
Okay. I don't see any additional questions. I think we've gone through the entire bill and the amendments, haven't we, Brad and Ben?
There's one more section that is fairly benign, but I do just want to flag it, if I may, Mr. Chair.
You want to pull that up, Ben?
Ben, this is the data collection section. I believe it's at the very end of the bill. I apologize. I need to have this thing memorized. Yep, it's up just a little bit there, Ben, about the data that the judiciary will collect. So obviously this is an issue that both landlords don't want to evict, and frankly, they need good data for this as well. So do the advocates and kind of the policymakers. Now that the judiciary is switching over to digital services, what we have proposed in this bill is an enhancement of the data collected and made publicly available. So to better inform this discussion in the future, I did just want to point out there's a delayed implementation on this section of the bill to October of 2025. That came at the request of the judiciary, who is confident that they will have all districts in the state switched over to a digital format for filing by that time, and so that they will easily be able to provide those.
Great. And ladies and gentlemen, I'm sorry, Delegate Boyce.
Very quickly, Brad, can they assure us of that? Because this system was supposed to be online 2 years ago, 3 years ago, 4 years ago, 5 years ago, 6 years ago, and it continues to be delayed. And they need to. How do you have an assurance? It's kind of funny, but it's not funny. Do you have an assurance that it's actually going to be done? Because every year it's supposed to be done, and every year it's not done.
So it's a fantastic question. Sorry if I smile, because I have been a part of many of these conversations. The assurance, Delegate, is that this does not require that it's done digitally. This requires that it's reported. And so if they don't get it done when it gets here, that's a whole lot of work potentially. And that's why we worked with them. That's right. And that's where they said, this is where we feel comfortable. Can we adopt this timeline?
Thank you.
Absolutely.
Thank you, ladies and gentlemen of the committee. Chuck, if you're still here, did you want to add anything, Chuck?
No, Mr. Chairman, I just appreciate being along for the ride. Thank you very much.
All right. All right, ladies and gentlemen of the subcommittee, if you have suggestions and or amendments that you would like for us to consider, please get them to us. We are going to be voting on this particular bill on Monday. All of you have probably already received agenda for this coming Friday and Monday. On Friday, we're going to be hearing several bills, as well as Monday, we're going to be hearing a couple of bills. All right. We're getting close to crossover, ladies and gentlemen. So you know the drill. We're going to be working overtime. I'm glad that you all are here because, as you all know, the overtime pay that we receive is fantastic. Time and a half times 0 is fantastic. All right. With that, ladies and gentlemen, the Housing and Real Property Subcommittee is adjourned. I will see you.